So for those of you who have not seen me before, my name is Tricia Teague. I am Chief Entrepreneur at the Trep School, and we have been providing technical assistance through a contract with DCEO, the Department of Commerce and Economic Opportunity, for just over a year now. And so I am excited to have everyone here tonight. SL contacted me recently about joining forces again for tonight's webinar. For those of you who might not be familiar with her, she is with UIC John Marshall Law School. I forget what CSEC stands for, but she will tell you later. And they also have a contract with DCEO providing legal assistance. And so the two of us work very well together. We put an impromptu session together a few months ago when the first round of deficiency notices came out, and then we've just been rolling ever since. So I am excited to be able to moderate tonight's session. I'll probably be learning just like all of you, because even though I've been down to Springfield and I have a personal relationship with both my state senator and my representative, I know that advocacy is vitally important, and it also takes a certain set of skills. It's not just to be able to talk to them about what your problems are, but also to be able to translate that into what you need for them to be able to do in order for them to make the changes that are necessary to be made in the law. So with that being said, because you all also know that I am a stickler for starting on time, it is 6:33, and so I am going to, let me back up. Let me also introduce our advocacy partners. Usually it's just SL and I here, so it's just like us volleying back and forth. But tonight we also have our advocacy partners from SEEM, which is the Social Equity Empowerment Network, Natasha Neptune and Belisha Royster. And so they are advocacy partners. They have been advocating on behalf of cannabis, I can't say licensees yet. I wish we could say licensees. Cannabis license applicants for quite some time now. And so they will also be chiming in on the legislative agenda. And so on that note, SL is our presenter for the evening, so I will turn things over to her so that she can jump into her presentation and provide us all with the wonderful tools and tips and tricks that I know she has up her sleeve.
Thank you, Tricia. That was lovely. I appreciate you taking time out of your girls' trip to be here with us. But if you look at this screen, this is a bit of a virtual girls' trip.
It really is.
And we're taking our trip down the legislative lane, which I'm excited to do today. So I'm just going to take a second here to pull up my workshop. All right, and Tricia, I would appreciate if you tell me if I'm not showing something.
Yeah, of course.
I appreciate that assistance from you. So
yes,
today we are here.
All good.
All right, cool. We are here for a legislative advocacy workshop on the changing Illinois cannabis laws. I am so happy to be here, especially with this powerhouse of just excellent queens tonight. We got Tricia from the Trep School, who is always doing an amazing, graceful, and patient job of organizing our technical assistance workshops. We have the Department of Commerce and Economic Opportunity, who often watches our recordings to keep up with what we are doing and what the agenda is and what the issues are. And then we also have a very special guest, the Social Equity Empowerment Network, SEEM, and they will be here for sharing their 2021 advocacy initiatives, which I'm really excited to hear. And I think they are an excellent partner to have with us tonight. So If you are familiar with me, you know I always have a workshop agenda. And today's agenda, we will start off with a brief law lecture. It might be a little longer than the ones we usually do, just because there's so many moving parts to the laws right now. So I'm going to probably take about 25 or 30 minutes when I usually take about 15 to 20 minutes to do a law lecture. And when I finish, we're going to take a brief break for about 2 or 3 minutes, and then we'll come back for part two with SEAM and their 2021 advocacy initiatives. And then we'll take another brief break, and then we'll open up for part three, which is our open group discussion with Q&A. All right, for those who are new to me, I am SL Owens. I am a Chicago native, born and raised in the west side of Chicago's Austin neighborhood, which is a disproportionately impacted area for harmful cannabis, the war on drugs. And I am also an experienced business and regulatory attorney with a background representing local, national, and international businesses. I recently had one of my students at John Marshall ask me, how did I get involved in the cannabis law? And I realized that I probably never shared this with you all. And that is, I started my career as a commercial litigator in a big law firm for about a year. And I really enjoyed doing the litigation part of regulatory law, but I didn't think long-term it was a good fit for me, and I wanted to move over to transactions. So I moved to a new firm and moved to a new practice group in corporate transactions and regulatory law, focusing on franchise distribution, supply chain law. And if you are familiar with franchising, then you probably already know that just like cannabis, it's a highly regulated area of law that involves local laws, state laws, international laws, if you're talking about international franchising, as well as distribution and supply chain. So it made it easy for me to make a pivot to cannabis law when I moved to my second big law firm after law school, and I was based in their Denver office. And if you're familiar with Colorado, then you know that that's one of the oldest cannabis markets in the country. So it does give me a bit of perspective in terms of what has happened in other markets as I compare what's happening in our emerging market. I work for the Community Enterprise and Solidarity Economy Clinic, CSEC. It's a legal clinic based in John Marshall Law School. We represent a lot of community-based and socially conscious brands. Our clients often have three qualities. They are equitable brands, they practice democratic decision-making, and they are often trying to build sustainability in their neighborhoods. We usually accept new clients twice a year in January and August. Our application is on our website for you to initiate the application process, and I will drop the link in the chat for you all. So the Social Equity Cannabis Initiative is a project that was jointly designed by the CSEC as well as the Illinois Department of Commerce and Economic Opportunity to reduce legal barriers of entry for folks who are trying to enter the cannabis legal market but have been harmed by the war on drugs. We have three main buckets of services. We do workshops like the technical assistance workshop we're doing tonight, where we offer related materials. If you've been to my workshops, you know I often provide a toolkit and worksheets for you to use to help you self-represent and self-advocate. We provide brief advising through email. I have received many brief advising requests from many of you, and that process has been going really well. To submit a request for brief advising, that can also be done through our website, and I'll drop the link. We also provide legal representation through our clinic application process, which again, that's the process where we take new clients twice a year in January and August. Our goal ultimately is to provide timely and equitable access through this initiative, which is why I do these ongoing cannabis law workshops, because that's sort of to bridge the gap in between folks who do not become our clients for the semester, but making the information accessible to everyone across the state. So to jump in, legislative advocacy, we have a bunch of changing laws in Illinois, and I am going to start off right away telling you what our scope is tonight. From my perspective, I'm looking at three categories for our scope. I'll be looking back to understand common areas of growth for social equity applicants and their advocates. So from this perspective, I'll be looking at what have I seen over the last 2 years that are areas where I think every social equity applicant can use some growth in the area of legislative advocacy. And then we'll be looking forward. And there I'll be summarizing some, not all, of the pending bills in the current 2021 legislative session. And then we'll be looking at some legal strategies on how to self-advocate during these complex legislative proposals. So the goal is to help you think like a lawyer as usual. I really appreciate feedback I get from you all after these workshops when you say like, hey, I really feel like a junior lawyer after this. So looking back, what are some common areas to grow for social equity applicants? Here, I think the number one growth area that I'm seeing that everyone could use building some muscle is around researching the key players. I think in the last 2 years, I've seen a lot of folks not really understand how to conduct what us lawyers call due diligence, which is just a legal term that we use in the legal industry for research. And it's exhaustive research. And I believe that my number one piece of advice for growing, moving forward for everyone is to really understand who these players are in the industry and how each category of players requires you to conduct specific type of research known to lawyers as due diligence. So we have the legislative branch players. And I think here, most of us think of, oh, those are legislators. But it's a lot more complex than that, which many of you have been finding out over the last 2 years. We also have political action committees, known as PACs, and interest groups, also known as special interest groups, with legislators. So these are, in these circles, you're seeing two categories of folks who are in the background influencing lawmakers. So political action committees, they can be summarized as groups that contribute to campaign finance and fundraise for legislators and politicians. And interest groups can be summarized as groups that form because they have common goals and interests in what they want to see in law, and they come together and they advocate for those particular interests. So that could be law enforcement, for example, that could be teachers, that could be groups that just focus on a certain business industry, that could be groups that focus on a certain policy goal. So, like Moms Against Gun Violence, for example. So I think it's important, and I think where a lot of folks missed the background noise that's important to participate in legislative advocacy is really understanding how PACs work and whether they should form PACs. I would highly encourage getting involved in this aspect of advocacy, as well as interest groups and how that could help you. And we have plenty of advocacy organizations specifically focused on the interests of social equity applicants, which is why we have an amazing partner here today that can share exactly what they've been doing, because everyone has different interests. And so it's important to kind of figure out, what are your interest groups? Who are the political action committees that represent you? And if there aren't any, how do you get involved? And then we have this group of players that I listed down the middle: the legislators, lobbyists, lawyers, and consultants. The reason I listed these in a row is because the truth is, they are like musical chairs. And if you've been involved in this industry for some time, you realize that legislators are often lawyers, lobbyists are often lawyers, consultants are sometimes lawyers, consultants are sometimes not lawyers, consultants are sometimes lobbyists. So it's important for you to sort of educate yourself on who these people are and where they exactly stand in the industry. And I think from there, you can really begin to do what I call due diligence, which we'll get into later in this workshop, where I'll kind of give you some tools for how to look up things and see who these people are and where their loyalties lie. Now, that's still not the full picture for understanding the key players in the cannabis industry. You also have the judicial branch and the executive branch, and they, are a bit of a check and balance on the legislative branch. So as you've been seeing, the court system will strike down laws and help fix laws that they find to be unconstitutional or unlawful for any other reason. And then we also have the executive branch. That would be like the Department of Justice, prosecutors, investigators from the federal government, sometimes state government. And in this branch, these are the folks, and as far as it relates to cannabis, a great way to think about them are the folks who are enforcing the regulations around campaign finance, laws around corruption, laws around conflicts of interest, and laws around antitrust. So those are some things to kind of think about in terms of the big picture of like who are all the key players in this industry. And when you're dealing with any new person in the industry, taking a second to understand where do they fit in this? Are they a legislator? Because legislators have a certain set of rules they have to play by. Are they a lobbyist? Lobbyists have a different set of rules. Are they a lawyer? Lawyers have a whole set of rules that we play by. Consultants? Consultants have a whole nother set of rules. One category that's not on here that I would like to see on here in terms of some of my own interests, which I don't typically get into, but I think this is important just from my perspective as a community-based attorney and some of the fraud that I see that is very frequent in the industry in my own communities is I wouldn't mind seeing a category on here for business brokers. That's not a category that we have for cannabis businesses and players that are regulated in Illinois right now, but for example, they are regulated in Michigan. And what that would do is require folks who claim to sell opportunities in the cannabis industry to register themselves and be regulated by the state. And from my perspective, it truly avoids a lot of heartache and fraud and people losing their life savings and just retirements and things like that. So I won't go too far into that, but I wouldn't mind seeing that category added. And then we always have the green machine, the market. The market is always in the background, swaying, influencing, and using money. And so this is sort of the full picture of the key players. And I think that when this process first started for a lot of people, folks were lost in the sauce. I don't think people really understood just how complicated this web of money, power, and influence is. And I don't think people understood just how this musical chairs work in terms of legislators turned lobbyists, turned consultants, or consultants turned lobbyists, you know, and lawyers who fit in pretty much any one of these categories sometimes. Sometimes a lawyer is a legislator, you know, so just kind of thinking about this big picture moving forward and growing in this area, I think would be very helpful to everyone for sharpening their legislative advocacy skills. The next growth area, and the second and only other growth area, because I really wanted to narrow this down to the top two. If you have ever received any wise advice from me, you know that I believe in the rule of twos, and I don't believe in stretching your message past that at any given time. So here, I believe that there can be growth in owning your public narrative. I think that there was a lot of misunderstanding about what role the media played and a lot of naiveness around what role the media plays as an institution that has its own agenda, its own biases, its own loyalties, its own, you know, because it has its own ownership structure. And those companies, I know from my time in supply chain work, which crossovers into marketing and media, those are often holding companies with all type of sprawling power across the world. And they also have their own ignorance in terms of informing the public discourse and opinion. And I often saw over the last 2 years, social equity applicants being taken advantage of in the media narrative. And one way I would love to see everyone grow is in this area of owning your story. Own what your story is in private and in public. Establish your own public brand. Establish your own unified public message. Who are you talking to? Who are your constituents? What do you want the public to know about you? Be selective about what media you work with. I remember when I first graduated from law school, I really thought the media was my friend. And what I mean by that is I was just very naive about how the media worked as an institution. And the legal industry, like cannabis, is an industry that's not very diverse, that has a lot of room to grow in diversity. So what that means is the very few of us Black attorneys, brown attorneys, non-traditional attorneys in every category that do exist, the media sometimes clamors all over us for stories. And what I learned quickly is, whoa, when I give up my story to them, it can take all type of twists. They can take my first generation college graduate, first generation attorney, single parent home, you know, just all of the things that my family was afflicted with, like everyone who was devastated by the war on drugs, mass incarceration, all of those things. And they can just morph that into a story that shouldn't necessarily be my full story, because my full story involves me being a Fulbright scholar, for example, you know. And so it's just things like that that I learned early on. Whoa, I've got to take control. And in doing that, I need to be selective about what media outlets I talk to. And I learned that sometimes no media is better than bad media, bad narrative, harmful stories. I also learned that it's good to develop media relationships and establish terms and conditions for press. What I mean by terms and conditions are, when folks are approaching you for statements, you don't have to just give them a statement and let them run with it. You can tell them that you will only provide a pre-approved quote, for example, and that you will not, you do not agree to your quote being changed. Sometimes I see statements from social equity applicants in the press where I know that's not exactly what they said. I see all these brackets, and it appears as though that network or that outlet changed a few things about what that person was saying. For me, I only approve exact quotes. I don't approve bracketing and summarizing what I said, because I found that many of these institutions also could use some diversity on their staff, and they just don't understand my intersectionality and my story. And I want to encourage all of you to grow in this area. So just as an example of some of the harmful narrative I saw, so where I have these two categories that I say: harmful media narrative I saw around social equity applicants in the last year or two. And then I say an alternative media narrative. If I were in this position as a social equity applicant and I was hoping to own my own story, the narrative that I would have wanted to put out there. So, sore loser. Not gonna lie, you guys, this one really got under my skin. I hated seeing my people categorized as sore losers because they want and demand due process and justice under the law after a harmful decades long war on drugs, which means that the government created war zones in our communities. And to turn around and categorize us as sore losers is an ultimate slap in the face from the media. An alternative narrative to that: how about advocate? How about entrepreneur? How about investor? Social equity applicants are not sore losers. They are advocates, entrepreneurs, and investors. And I'm sure you all can make that list go on and on and on, and so can I. Another harmful narrative that I saw in the media: infighting. This is another one, and a more recent one. This is another one that really gets under my skin. And I gotta tell you, it's really hard to get under my skin. I'm a pretty chill person. Infighting is another one, because I felt like, how dare you reduce the advocacy going on to infighting or some type of petty squabble that is not serious policy discourse. And I thought, would any other special interest group or any other super PAC or any other political advocacy groups or activists ever be reduced to infighting? And quite frankly, I thought that there were racial undertones and biases and ignorance in both of these narratives. Alternatively, how about calling it debating, lobbying, educating? Because from my perspective, that's what I saw happening. I didn't see infighting. I didn't see sore losers. So this is just an example of what happens in the public discourse and opinion. Because at the end of the day, you do want to have ownership over the public discourse and opinion when it comes to legislative advocacy, because you want the citizens of Illinois to agree with you. You want to influence them. but how can you influence people who have been predisposed to thinking of you as a sore loser who engages in infighting? Some solutions to this, just to sort of wrap this part up, I think some other solutions to this is, now this is pretty extreme, and this is pretty much the stance that I personally take in my professional life, is I don't do media. I don't do media because I find that media has a lot of white supremacy ideologies that does not reflect intersectionality unless you do your research and really find out who's in charge of that media and who owns that media and who is on the writing team, who's on the editing team. It takes a lot of work to sort of get past that fog of supremacy. So from my perspective, since my early days of becoming a lawyer, I don't do media. I only end up in the media if they find and do it themselves, but not with my participation. Instead, I create media because we are living in a time where we don't need the media per se. We can create our own blogs, our own newsletters, our own social media content, our own videos and commercials, really our own YouTube channels, our own podcasts. So now I'm not saying it's just so easy, like you just snap your fingers and have this done. I'm just saying, from my perspective, it's worth it to think about organizing, creating your own media channels to control your own media narrative. All right, so looking forward. So let me, before I jump into this part, I really want to make sure that I set some expectations here. As my advocacy partners on the line know, because they are deep in the trenches doing this work, there are a lot of moving pieces to the legislative process, so much so that there are tons of bills that are up this season in 2021, many related to cannabis, but not all of them are related directly to social equity applicants. And not all of them have the sort of importance for understanding as others when it comes to being a social equity applicant. So what I did is, this is not an exhaustive list. What I did was I chose select bills that, from my perspective and my experience lawyering over the last 2 years here, and my perspective lawyering back in Colorado, are things that folks should pay attention to when it comes to the proposals that are being put forth right now. And I also, in terms of if you're in the category of a person who is interested in entering the cannabis business market, all right? So I don't include things that have to do with cannabis, but don't necessarily directly impact on the social equity applicant status. So for example, there are bills that have to do with changing the allocation of where the tax money goes to, decreasing it from police and increasing it for mental health, for example. That bill is not on here. Because at the end of the day, social equity applicants pay taxes, but they don't, control necessarily where the money goes. And if you are interested in being a part of that part, that certainly is an avenue of advocacy. But as you'll see, there's a lot of moving parts. And when you're engaged in warfare, you really have to kind of trim down where you use your resources. So it might be a fight that social equity applicants decide to engage in later, but because you're facing so many serious business hurdles to even entering the market right now, I'm not focused on the laws that have to do with folks that are already in the market to an extent. And so I'm also only providing summaries of key provisions and not all the details of each proposal, because we would be here for a very long time if I did that. So starting up, number one, the first one. So we have a proposal right now to create a cannabis control commission. So at the moment, cannabis business licensing is controlled through two main departments. All right. The licensing process in particular, the Illinois Department of Professional and Financial Regulation, and the Illinois Department of Agriculture. If you've been in this process, then you know that there have been a host of issues pointed out about both of these administrative agencies and how they are handling the licensing process. Every state does this differently for legalization. Some states, for example, pointing to our closest legalized neighbor, Michigan, has one agency that covers cannabis, right? And so what Illinois, some legislators are proposing is doing something similar in Illinois. Instead of having these two different agencies dealing with the cannabis business licensing, they're proposing creating just one cannabis control commission. I think some of the key things to think about here in terms of trying to interpret this bill when you pull it up is, what does it mean for it to be a 7-person commission plus an executive director, keywords appointed by the governor? What does that mean when this is a politically appointed and possibly politically charged commission? So I think if I were reading this, through my attorney lens, that would be my first question. Whoa, this appointment process could be politically charged. How is that going to work? What does that look like? And how would that impact the process moving forward? Then there's a proposal for cannabis business delivery organization license. All of this PowerPoint, as well as all of my tools, will be available to all of you through a shared folder that I'm going to drop momentarily. So do not worry about writing any of this down. You'll have the recording and you'll have this actual PowerPoint slide. So in this proposal, it is proposing creating new business license category for cannabis delivery licenses that only social equity applicants would qualify for, and to be administered by the Illinois Department of Professional and Financial Regulation. So here, the key that I would think of is like, whoa, this is a whole new licensing category. What does this mean? Where would this fit within the supply chain, right? So especially when you have closed supply chain systems, meaning there's only intrastate commerce because of federal prohibition, there's no interstate commerce. I'd be thinking with my supply chain lawyer brain, where I'd be looking at that bill and thinking, what is this group? What kind of power do they have in the supply chain? What is the hurdles to entry in the market for a group of licensees like this? Those are the kind of things I'd be thinking. Then we have a bill that is for dispensary delivery to purchasers that would empower dispensaries to deliver cannabis or cannabis infused products to their purchasers. Again, I'd be thinking, for me, from my perspective, okay, what does it mean for dispensaries to add this line, this channel of commerce to their business? How would that impact me if I'm in another area of the industry? Or if I'm going to be a dispensary, how does this improve or possibly hurt my supply chain standing? Next, we have expanding craft growers. So this one has a few parts to it. One that's about expanding the square footage and in increments by rule based on market need, which means that's not something that the people will decide. That's something that agencies and government employees will decide, as well as increasing the opportunity for her square footage to be increased based on compliance. And the compliance way means a business has demonstrated that they are in good standing with their regulatory compliance requirements and have demonstrated that they can handle a larger square footage. This proposal is also looking to disallow the Department of Ag from decreasing flowering stage cultivation space used for cultivating specific plants. It's looking to raise the maximum number of craft grow licenses for specified craft growers to 3 rather than 1, 6 rather than 2, 10 rather than 3. Again, many of the ones that have to do with the business license, you're going to hear me say the keyword supply chain. How does this impact me if I'm in this industry and where I stand on the supply chain? If I'm a cultivator, what does this mean? If I'm a dispensary, what does this mean? If I'm a craft grower, what does this mean? And what does this mean if I'm a craft grower who can't afford, for example, to get it in like this with these square footages. Not, so I would be thinking about like all of the hurdles from a supply chain perspective so that I can understand what's written in this bill. It removes language prohibiting craft growers from being located within 1,500 feet of each other. Again, that could be good, that could be bad. I'm not saying either way here because these are really kind of personalized decisions that have to do with your resources, your ownership team, your ownership structure, your access to financing, etc. It's also looking to prohibit cannabis product advertising from describing or referencing a cannabis product as craft unless the cannabis product is in fact produced by a craft grower. It's looking to not assess the tax until 2 years after the date a license was awarded. I think that's something interesting to think about. If I'm a dispensary and I don't have this privilege, if I was a dispensary, I'd be thinking, I think I want a privilege like that. I mean, who doesn't like tax privileges? So this is just sort of the way I would be approaching looking at this. The next one is Local Cannabis Licensing Act. In the original laws that were passed for legalization for adult use, there was a lot of confusion over whether local municipalities and counties were going to be empowered to issue what's known as consumption licenses in some places, event licenses, start cannabis clubs, entertainment licenses, lots of ways to phrase this. And there was also a lot of conflict in the law in Illinois in terms of Illinois Smoke Free Act and how that would all work together. This proposal is aiming to clean that up by allowing municipalities to indeed issue licenses for temporary events, cannabis clubs, cannabis tours, cannabis events, and all of those fine, fun entertainment things that is an entirely niche place to be in the industry. Before COVID-19, it was a different story being in this space than post COVID-19. So from my perspective as an attorney, I'd be thinking with my client through, okay, what does this mean in a post-COVID world? Where are people with smoking, consumption, and things like that? How will this look and be done safely? And where do I sit on the supply chain? How will I be able to get cannabis? Oftentimes, these type of rules don't allow you to sell cannabis on premises. So these are things to think about. When you have a liquor license, for example, you sell liquor. People don't just come and drink. In these situations, often it doesn't come with that. So that's what I'd be looking for in the bill. How will I get product? What's the zoning going to look like? How does my locality feel about this? Because if I were in a locality that's been pretty anti-cannabis, then I'd start having to lobby my locality in addition to state legislators. CDP Safety Act. This one establishes labeling and testing requirements for hemp-derived CBD products. Again, I'd be thinking about my bottom line if I were in the hemp industry. Well, how much is that labeling and testing going to cost? I'd also be thinking if I wasn't in that industry yet and I was looking for an aim, who's going to get the licensing and contracts to do the testing? If I were in the sciences space, I'd be thinking, I wonder if I could get a license to do the testing. And so that's just, a way I think of this. And then the big, what's probably considered the big whale, the big fish in terms of social equity applicants. And we have the lovely, very knowledgeable Scene here. So I am not going to belabor this bill. I'm only going to summarize it. And this is the bill that definitely affects social equity applicants because it affects the definition of a social equity applicant and their status in the state. So some of the main provisions are to expand emergency rulemaking authority of state agencies. If you are not familiar with emergency rulemaking, I would get myself familiar with it, which I will demonstrate to you in a second. It creates a non-competitive process for social equity applicants for a social equity medical lottery to issue remaining 5 available medical dispensary licenses. As you know, Illinois operates on caps. So we don't have unlimited licenses. We always only have so many as approved by the legislator. Lowers number of required application points and eliminates the perfect score conditions. That was one of the causes of so much litigation over the last year to secure dispensary licenses while releasing additional licenses for additional lottery rounds. It also creates a social equity justice involved lottery process where there is no employer-based social equity applicant route of entry, another very controversial part of the law, and removes employer-based social equity applicant route of entry under the definition of social equity applicants specifically. What's not on here is that it also increases the amount of time that you needed to live in a DIA from 5 to 7, I believe. Don't quote me, it's in the bill. It also limits applicants from participating in numerous lottery rounds and limits the number of licenses an applicant can secure per lottery, while also limiting the number of times the same principal officer can be entered into a lottery round. Another very controversial part when you think about market entry, who has financing to afford to constantly and consistently put forth hundreds of chances for themselves. Eliminates inspection requirements as a condition before receiving a conditional license for a dispensary, and removes requirements of conditional licensees to provide what they called a detrimental impact statement, where applicants basically had to say, here's a reasonable statement that my dispensary will not cause a detrimental impact in the community it will be located in. And it also tightens up the definition of control. Again, we have seen here, and I'm sure we'll be fleshing out more of this with them, so I'm not going to go any further on that at the moment. Now I'm going to move into some tools for advocacy, but before I do that, I am going to drop you all a link to the box folder and give you a second to pull it. So everyone take a few minutes here to get into that box folder so that you can see some of the worksheets. And the first worksheet I want you to pull up is called a due diligence resource list. And we've tested the link a few times, so hopefully there are no problems there.
So if you decide to download the document, because there's a couple of different ways you can open the document and it'll pop up on your screen, but if you decide to download the document, a box will come up asking you to sign up. You don't have to worry about that. It will download anyway.
Thank you, Tricia. Scene, were you able to pull up the sheet? Okay, awesome. Sweet. Great. All right, I'm going to share my screen again here. All right, so we're going to jump into some tools and legal strategies. So the number one strategy I have tonight is to conduct research like a lawyer, going back to that keyword I used earlier called due diligence. I want you to think about the fact that you should conduct due diligence on everyone. And I mean everyone, including me. And that's how serious I am about due diligence and protecting you from fraud, who you encounter in cannabis. This includes understanding their credentials, their associations, their affiliations, their conduct history, their financial and business interests. Because going back to that common area of growth that I talked about earlier, not understanding the players. This will help you understand the players. It will help you avoid scams. It will help you avoid undesirable affiliations, and it'll help you avoid biased advice. So if you take a look at that, I'm going to pull up that list, and I'm going to explain how to use each piece of this due diligence. Tricia, is my due diligence sheet showing now?
Yes, ma'am.
Okay, sweet. All right, so what I have here is not an exhaustive list of due diligence. Due diligence in the transactional world of law is a process that often goes for months at a time. And it's specific by industry, it's specific by deal, it's specific by what you're trying to do. What I did was I put a list together of free resources that any of you can access. There are tons of other tools that lawyers have access to that are not on here. And as I think about this, Tricia, you know, whenever I'm teaching, I think of a new thing. I'm going to write a note for myself to update this list for you all when we finish tonight, to add how to look up people's lawsuits, because you can look that up for free. And I'll get into why you should do that shortly. So Illinois attorney due diligence. This is an area of fraud and scam that I regularly see in the cannabis industry, not just here in Illinois, but definitely a lot here, but also in other states. What I mean by attorney due diligence is when someone presents themselves as having legal expertise, being an attorney, being able to help you do legal work, please check and confirm that they are at minimum a licensed attorney. That is very easy to do. You can go to the ARDC website that I linked here. You can put in their name. You want to test it out. Again, I said conduct due diligence on me. You can put my name in. You can put in S.L. Owens, last name, and it will pop up showing you that I am an active member of the bar. It will tell you when I became licensed here, and it will tell you if I have malpractice insurance, I believe, and it will also tell you whether I have any disciplinary infractions on record. This is important. I have seen so many people get tricked into thinking that they're working with a licensed attorney when they're not. I've seen so many people presume that because someone is presenting legal information to them, that they are a lawyer. Another reason this is important is because lawyers, unlike many of the players I discussed in the industry, we have a whole different level of rules to play with that are for public protection in ways that maybe consultants who aren't lawyers don't have to do. So let me give you some examples. Lawyers have a duty of loyalty to our clients, meaning we have to legally be loyal to you. When you are in an attorney-client relationship with us and an attorney engagement, we owe you loyalty. That's not something that consultants that aren't lawyers necessarily owe you. Lawyers have a duty for how we handle our clients' money. All right. There are rules around trust accounts and fiduciary responsibilities, and the bar has outlets for you to be repaid money that is misappropriated by an attorney. There are funds and pools for that, unlike other professionals. Lawyers have a duty to assess conflicts of interest in everything we do. I have seen this so much over the last year. People realizing later, like, whoa, that was a conflict of interest. This person was helping me with my application and they were also applying at the same time. And I didn't know. I'm not saying that's a bad thing. I'm saying when you work with a lawyer, we have to disclose and give you that analysis. We cannot be competing with our client in the same application round, for example, without saying, hey, by the way, I'm also doing this. So it's just a sort of different way of playing when you work with a lawyer than when you work with other professional. And it's also sometimes why lawyers cost more money, because we have regulatory rules that are costly, just like being in the cannabis industry. So these are the sort of things I want you all to think about when you're doing due diligence on your lawyers. You can see, have they been sued by their clients? Have they been in trouble with the bar for doing something bad? You know that they owe you duty of loyalty. They owe you a duty of communication. They owe you a duty of care around how they handle your case. They owe you a duty to not be in conflicts of interest, meaning representing parties that are in conflict with you, being in conflict with you themselves. So those are the types of things to think about when you're working with an attorney or assessing an attorney. I would also, and I always recommend that, lawyers are very personal relationships. So I recommend that folks, get a consultation from 2 or 3 lawyers. Find out who's your jam. You might flow with some people and not flow with others. All right. Illinois legislator bill due diligence. Here, Look up the bills for yourself, pull them. All right, see what's in them, see who's sponsoring what. Who are the sponsors on this bill? Who are the co-sponsors? Who initiated this bill? If I were doing some legislative advocacy work, that's what I do. I'd see. And by the way, I also often check and see if legislators are lawyers, because that means that they also should be operating under the conduct rule of lawyers. That's what comes with having an active license. All right. And so after I look up my bill and see who's involved, the next thing I would do is I'd see what is the lobbyist and lobbyist activities going on, and what are the campaign contributions going on. A common pitfall, going back to earlier and not understanding the players, is not understanding the money. I think it's important to understand how money is influencing the cannabis industry and cannabis legislators. You can easily look up in Illinois using this link, who's getting money from who and how much. It can help you begin to have better context of what is going on. If someone is presenting themselves to you as a lobbyist, check and see if they're registered, check and see if they're active, check and see who they lobby for, what they lobby for, who they lobby to. And when you look at the lobbyist stuff, you can even look it up by entity. If you click the link, you'll see, you can just put in the entity. You can see what companies, institutions, and organizations are involved in lobbying and how. You can also look up business opportunity and securities registrations. The state requires folks who are offering, these are things like multi-level marketing regimes, things like that. Things, I'm seeing this happen often in, like, you can open up a CBD dispensary and, you know, similar to franchising almost. Look them up. Do your due diligence. Don't just believe the disclosures that they tell you. You're going to make $5 million in 12 months. Look up what the registration materials are saying about them with the state. Another one that just really breaks my heart that I see often, as well as in the cannabis space, is real estate agents and real estate brokers. There's a lot of scammers. I've had to go after them in Illinois, claiming to be brokers. Turns out they don't have a broker license. Turns out they don't have a contract with that property owner. They're faking and fronting. They take a security deposit from you and disappear. Look these things up. Do your due diligence. Illinois company due diligence. Put them in. Who are they? Who's their registered agent? Do they list any of their owners? Are they active in good standing? What are all the names they go by? What assumed names do they have? Illinois state contract due diligence. Tricia opened up this webinar saying, hey, this is how SL and I know each other. We're Illinois state contractors. We get paid from the state to do services. This service that we're doing tonight. Illinois Attorney General fraud alerts. What is the AG saying is a common fraud going on right now? Who are the fraudsters? One that's not on here that I'm going to add, as I usually add to materials after hearing your questions and going through the materials, is records of cases. You can look up if a company, you thinking about hiring a vendor to do your security work, look them up in the Cook County court system or whatever county, you know, all of the different counties where they do business. Has any of their clients had to sue them? Have they had to sue any of their clients? This is the type of work attorneys do around due diligence. What I gave you guys is just a little sample. All right. I don't want you to think after you use this list, you now are an ESQ super lawyer. What you are, you're still a novice. This is just a start. Trust me. If I'm looking up your company, I'm doing a lot more than this. All right. All right. Because I'm approaching it like an attorney, and we have a whole nother set of tools that are not necessarily accessible to non-attorneys. You know, or just not the kind of things you guys do, you know, in terms of property record searches and Liz Pendon's record keeping. And if you know, you know. If you don't, rewind and Google. All right. Trying to see who's out here in these bankruptcy records talking about they gonna be my investor. Okay. Okay, big bucks. I'm just, you know, everybody who's been with me before knows I'm going to keep it all the way 100, bordering West Side. Look them up, people. All right. You don't need a lawyer for this basic due diligence. Stop listening to what folks tell you and look at their actions. Have they been sued? Why is their company not in good standing with the state? What legitimate business owner is not in good standing? I'm sorry but that's the, you know, I ain't trying to make anybody tight who got a NGS on their record right now. But what I'm saying is, how you ready to do a deal when you can't get the basics done, and I'm supposed to trust you to get some business done for me? Stop letting everybody tell you they're a lawyer, y'all. All right. It's a reason why we go to law school, take the bar, undergo character and fitness evaluations and licensing. I should know because I did it in 3 states. All right. Look them up. Where are they a lawyer at?
Can I add one thing to that?
Please.
What type of law they practice?
Come on now, because I see a whole bunch of cannabis lawyers in a state that just legalized. I came from Colorado, baby. I'm from here, but I'm not new to this.
There were, and people going through their deficiency notices or, you know, asking for assistance. You know, there are people who are coming to me saying, well, my lawyer looked at this, especially with the deficiency notices. My lawyer looked at this and said we did everything that we were supposed to do. Well, if the agency that's issuing your license is saying they're missing something, then it really doesn't matter what your lawyer said, they're missing something.
Right.
And some of it was very, very simple, especially after going through the webinar that we did together on deficiency notices,
right,
which is go and read the law and follow the letter of the law.
Right. But they may not have been cannabis attorneys, meaning
exactly.
Maybe they were commercial litigators, maybe they were criminal defense attorneys.
Exactly.
Maybe they're trying to make a pivot into cannabis law. But when folks ask me, you know, I just had a law student ask me, what can I do to get prepared to be a cannabis attorney? These are folks who have backgrounds in administrative law, first and foremost, meaning they have experience working with agencies. All right. That's a whole specialized category of law. That's how I pivoted in this, because franchising is a bunch of administrative law, federal and state. Distribution, marketing and media law, those things I did when I was in the big law firms, regulated, right? And so that's administrative law. So if you're working with an attorney, you're going to ask them, what's your experience in administrative law? If they're new to it, doesn't mean, I'm not saying they can't pivot. Come on now, I ain't hating on my sisters and brothers out here. I want y'all to expand. I've been seeing many come to these workshops so that they can get educated on how to expand. So that's not what this is about. This isn't about downing. This is about helping you avoid frauds and scams and misrepresentations. Another area that I tell law students to explore while they're in school is local government law. Slightly different than cannabis law. I mean, administrative law. Slightly different, a little bit more nuanced in terms of the local municipalities and all of their different rules, which is a whole nother set of cannabis laws, by the way. Tonight, we're talking about the state, but we haven't started talking about what's the city of Chicago doing, what Cook County doing, you know. So local government law, labor and employment law, business associations, all right? So just know when it comes to legal, particularly in cannabis, you need to be talking to lawyers, number one. Number two, you need to be talking to lawyers who are licensed in good standing and not people who just went to law school, all right? There's a difference between a Juris Doctorate and an Esquire. Over here in my household, we have 2 Juris Doctorates and 2 ESQs, meaning we went to law school and we're licensed and practicing. There's also a difference between people who pass the bar but never touch any casework. They're non-practicing licensed attorneys. That's a thing. Understand, what do they actually do? So, you know, my family will tell you, call me up. I'm like, I don't do that. Let me show you some people who do that. You know, I stay in my lane. Regulatory, administrative, business, local government, transactional, deal making, mergers, acquisitions, buying, selling business, property. That's me all day. You start asking me about criminal. All right. I believe the last thing that I wanted to share with you all is that how to look at these bills. So just pull it up. There's another sheet in there that you should see. And it's called a bill analysis worksheet. All right. I put this together to help you figure out what questions to ask yourself when looking at these bills, understand what revisions you want to propose, and how to create an advocacy plan. So, Tricia, tell me if I pull this up. I'm going to now try to pull that worksheet up. Do I have it up?
It has not popped up yet.
Okay, let me try it again.
Here we go.
Okay, perfect. If you've been with me, you know the first sheet is my disclaimers about how this isn't legal advice. I am not your attorney. I am your educator tonight. All right, go to the second page. And this is what I would do with each bill. Number one, if you got a team, please work with a team, because this can be complex, and depending on how many bills you want to tackle, then you need a team. If you don't have a lot of person power, then I would really kind of go through and say, what fights can I fight this legislative cycle? What do I have to just let go? That's what I would do first. And then I would pick up the ones that are going to be a part of my fight. And I would fill out this chart for each bill that I'm dealing with. I would start with a specific citation in the bill. Then I would put in the cross references. Then I would put in a summary of the text. This here is for me to help understand myself, my own words. This isn't the legalese as we call it. This is the English, plain language. And I would note any drafting errors because they matter. In law, they matter down to if they mean may, can, shall, or will. They matter on that level in law. I would note them. So as an example, in that folder, I have a example bill, the one I said I wasn't going to get into a lot of detail with, that's about proposals to changing some of the cannabis laws and that affects the social equity applicant status. I'm going to share my screen again so that you can see what I mean when I say how I would fill out this chart. All right. You see it, Tricia?
Yes, ma'am.
All right, so on this opening page, the first section in here, and I would take this section by section. They say that they're going to make some emergency rulemaking changes to the Illinois Administrative Procedure Act here. So on my worksheet, I will put in, I'm looking at amendment to House Bill 327, and I'm looking at this specific section, the section on emergency rulemaking. This bill is citing to other law, not necessarily Cannabis Regulation and Tax Act. So I look at this and say, wait a minute, what is Illinois ILCS 100/5-45? And I will pull that up. I will pull up the Illinois Administrative Procedure Act. That's what I mean by inserting the cross references. I think that's something that folks who aren't attorneys might kind of miss. Like, don't just look at what's on the page in isolation. Look at it in reference to what it's cross-referencing. Because that's where you'll find emergency rulemaking procedures, and you'll begin to understand the context of this. So I just wanted to point out at least one example to you all. All right. So I'm putting in my specific citation. I'm putting in my cross-reference. I'm doing a summary right here. What are they saying they're going to do? They're going to broaden the definition of emergency rulemaking. Let me look at this administrative law rule and see what that means. And then I will point out any drafting errors I think I see. The reason I'm organizing like this is so that me and hopefully my team can divide and conquer this and come up with what our proposals are going to be and demonstrate to our legislators we know exactly what's in these bills, because as I've said numerous times to folks, do not presume that legislators know what's in these bills. They got whole machines, staff, all right? I worked on one staff before. So I know personally we write a bunch of stuff for them scripts, research it, write it, draft it, and then they have like just a tiny little talking point thing. So don't presume they know. Tricia, I am sorry that I went so long. I did not realize, I usually don't go this long, but it's a lot. Legislative, and this was me condensing, so I apologize for that. But the good news is, you can send me brief advising questions about your legislative advocacy through the brief advising program. I'm going to drop that link. And I'm going to take a 1-minute break here, if that's okay, Tricia.
Yes, that's fine. And while you're taking that break, I'm going to loop back into the portion where you talked about telling our own story. Because I also have a background in media. My first degree is in journalism.
Perfect.
And I own the newspaper. So while SL is taking her break, you can leave your audio on or off. It's up to you, SL. I want to make sure that I want to add to what she said in terms of owning the narrative. And one of the ways that you can own the narrative is if you continuously engage media on your own terms. So if you show yourself, I won't say media friendly, that's not the right word, but you'll appear media friendly if you're putting out your own PR on a regular basis. Do your own press releases. Because if you do, I'm gonna tell you something, as a journalist, as a person who once owned a newspaper, reporters are lazy. And also, on top of that, not only are reporters lazy, there are less and less of them. So that means that the amount of work that is being done in a newsroom is being done by less people than were in a newsroom 20 years ago. They're trimming their staffs significantly. So reporters love when an organization or a business sends them a press release that has all the talking points, including quotes already in it. Sometimes what you will see is that they'll take everything you put in your press release verbatim. Why does that matter? Because then they're not calling you, asking you gotcha questions. Then you know that everything that you want to be said will actually be said in the way you want it said, because you put it all in the press release. And if they're calling you, they're just going to follow up on the fact that you sent them a press release, and that they might have one or two follow-up questions, or they might ask you something pertinent in terms of the date and time whenever that story might run, or whatever the situation may be. So if you do your own press releases on either a regular basis or on the basis of, every time you do something that's important and interesting, you'll get noticed. You might not get noticed as much as you would like to. They might not run every press release, but they will pay attention. And then that will be your way of telling your own story to their audiences, and to the public at large. So that is one way that you can really use the media for your own purposes without having the media bait and switch you. So SL is back, so I'm going to turn it back over to her.
I am finished. I am turning it over to Scene.
Oh, that's right.
Well, thank you, everyone. My name is Natasha Neptune. I'm the president of SEEN, Social Equity Empowerment Network. We are a trade association created by social equity applicants for social equity applicants. And part of our mission is really about safeguarding and implementing equity and promoting inclusion into this arena of cannabis. And it's very important for us to advocate on behalf of our members, our network, and our communities, because we know how disproportionately impacted the war on drugs has been. So, I would like to share with you, both Felicia and myself, and I will turn it over to our vice president for her to introduce herself to the community before I go into our 2021 initiatives.
Hello, everyone. It's a pleasure tonight. I know that we haven't had the opportunity to collaborate yet. So once we had the conversation with SL a couple of weeks ago, it happened organically. So this was all in divine order, I presume. My name is Felicia Royster. I'm the vice president of SEEN, the Social Equity Empowerment Network. And just as Natasha said, we were formed specifically as an interest group for social equity empowerment, and to make sure that we infuse and implement equity and eliminate barriers into the cannabis industry here in Illinois. Natasha?
Mm-hmm. So it's very important for us to communicate our stance. What are our initiatives for 2021? I mean, with everything going on, we've seen a lot of activity and issues surrounding this licensing issues. So in terms of our platform, we support having 2 dispensary lotteries. One that would support what they call this perfect score veteran teams, and then having an additional retail lottery providing for more veteran and social equity led teams to enter with an 85% cut score. And not only that, I mean, we are advocating that this lottery 1B occur no later than 24 hours of lottery 1A. And that is just to ensure that, we always felt like if we're going to move, we want to make sure that we're taking a look at the community. And I think this will help restore some trust in the system, considering everything that has happened and transpired. I don't know, Felicia, did you have anything else to piggyback on the lottery? Okay. And then not only that, just taking a look at some of the other license types, we definitely support the release of these 40 craft grow licenses, as well as increasing the release of the next 60 craft grow licenses, as well as the 40 infusion and qualified transportation license awards in 2021. And as part of what was discussed earlier with the craft grow legislation, we do support increasing the canopy space to 14,000 based on capacity of that applicant. I mean, as the bill The bill was originally 5,000, and we know that there might be some social equity applicants that might be able to do more than 5,000. And we understand there is a difference with the economy of scale, and really taking a look at how the current MSOs are really controlling the supply. And they want to continue to control the supply. And if, just for an example, the existing MSO cultivators have a 200,000 square foot canopy space, whereas here they're starting us, it's really like a micro business starting at 5,000. So, I mean, you know, we wanted to take a look at that economy of scale, and that's still, you know, up for debate. And then another issue that's very important for us is not to allow relocation of any existing dispensary license holder until at least half of the veteran and new stores are open, or at least 1 year after the disparity study. I mean, you know, social equity applicants haven't even gotten into this game yet. And already, you know, there's proposed legislation allowing for relocation so many months. And as we know, location is very important. And we have to definitely take a look at that whole spectrum and understand, how is this moving the needle of social equity? You know, allowing relocation to happen even before we even get into this into this industry. So those are some of the key issues I definitely wanted to raise in terms of our initiatives for 2021.
Can I add something to the relocation? I just want to call to the, everyone's attention that it's important that we also stand with our governor. Right now, the governor did issue a statement in 2019, and his stance on relocation, and he quotes, "It is unreasonable for current cannabis business owners to relocate in the midst of the onboarding of the new small businesses in the industry." He also adds that such an action would further impede on chances for viable businesses and also devastate these entrepreneurs. And so if we're keeping in mind that we're looking to have equitable opportunities and entry points, ultimately relocation is something that I think, as SL so eloquently stated earlier, that we need to be focusing on not the current industry, but the industry that we're trying to create, a more diverse opportunity for social equity applicants and people that were harmed by the war on drugs or the war on people. And so we want to be very intentional as we proceed into creating these opportunities. I think that it would also impede further opportunities, possibly even connecting this to the disparity study may be a good idea as well. Go ahead, Natasha, I'm sorry.
No, that, you know, we just wanted to share that with you all in terms of our initiatives.
Well, thank you very much, Natasha and Felicia, for sharing those. Now, if you have any questions, and we do have one in the chat already, or in the Q&A box. If you do have any questions, please type them in the Q&A box. There's been a little bit of activity in the chat, but don't type them in the chat because sometimes questions can get lost in the chat. So we have the ability to keep the questions and queue them up and move them once they've been answered in the Q&A box. So that helps us not miss any question, and we want to make sure that we answer everyone's questions. So the first question, which came up very early, does craft grower mean someone who is looking to plant, grow cannabis, and then sell it to the dispensaries? The short answer to that is yes. That is the only license that's also currently available right now under the law in terms of growing, although the whole reason why we're here is that it's emerging and changing and, you know, evolving as we speak. So there may be other licenses coming up. We'll see what happens. But at the moment, that is the definition of craft grow. And there is also, I should point out, especially since SL is here, there is a legal definition of craft grow under the law. So, but the short answer for the moment is yes, that's what that means. The next question that is in the chat is, SL, what does non-competitive process mean?
So in government terms, because we're just talking about in the government context here, there are usually two ways competitions happen. And this has to do with for grants and contracts, as well as for licenses. There is what is the public policy favorite and the norm and the default rule, which is a competitive process, meaning opening up the opportunity for every single person to apply for, know about, get notice to. There are state laws that require notice around these competitive opportunities, to where there has to be public postings, there has to be a certain window that the opportunity is open for people to compete for, right? So that's the competitive process. Non-competitive is a process by which the government, for whatever special policy reason, is supposed to be a special policy reason, can not use the default rule competitive and instead make it open only to a select group of people. This is often used in what's called single sourcing contracts, which looks like what may have happened with KPMG, where they did not have to compete against other potential vendors for that contract. So that's kind of an example of like the kind of things that can go wrong when you have non-competitive processes, but they can also be used for good, meaning to help certain groups that have been locked out of opportunities historically gain access to a market that is starting to be dominated by power players that are making it difficult and anti-competitive for new entrants, which is the context I think the legislation is going with these non-competitive processes. So that would mean that it's not open to everyone. Non-competitive in this context that I think you mean means it would be open to people who qualify as social equity applicants and only to those particular people.
And that's very important because there are a lot of people who assume, and depending on where you are in this process and how close you've been to this process in the last year, you might not know this. I've encountered many of these, and I'm sure all of us probably have. There are a lot of people who assume that because they're a minority that they qualify as social equity, and that is not true. You have to read the law to understand the rules behind what the state deems as social equity, and then whether or not you consider or you fall into that category. Now, why this is important is because social equity is one of those things that's being considered for changes. So what was social equity, one of those ways SL already covered, is an employer could employ 51% or more of his or her or the company's employees qualifying as social equity. Therefore, the employer qualifies as social equity. That is one of the things that's in one of the proposals that's possibly could change. So there is and so this kind of supports SL's original point, which is go back and read what the law says, because for everything that they provide in terms of these terms, there's always a legal definition. So you have to understand what the legal definition is to be able to know what direction to go after that. And since we know the law changes, those legal definitions can possibly change in this legislative session. And you as advocates can go in and say, I do want this to change. I think this is a good thing, and call your state representative and call your state senator and say, this is why I want this to change. Or you could say, I don't want this to change, and this is a bad thing, and this is why I don't want this to change. And whatever situation you're in is going to determine how you feel about each one of those individual changes.
I think that's an excellent point, Trish. And I want everybody to really caution as we advocate and navigate this whole system. Two things. How does this get us to implement more equity? And how does this safeguard equity? And so I think if we keep those things in mind, where we're trying to create entry level points or, points of entry, how does this create equitable entry points? And how do we safeguard equity? And I think that if we keep that at the helm of the decisions that we make as we navigate these new laws, then we'll get to the point or to the promised land.
Mm-hmm. And I think it's also beneficial for people to participate in the conversations that you all have at your meetings and whatnot, so that they understand the nuances of the changes, because something could be written and could be tout it as if it's a good thing and actually turn out to be a bad thing for people because of the details of how it is written or how it's implemented.
Yes, as they always say, the devil's in the details.
Absolutely. Okay, so the next question, we do have some questions. I'm glad we have questions because I was getting worried for a second. Usually I'm so used to like there being this long list of questions, but all right. So next question is lawyer versus consultant, both have background in marijuana and other states, which is better?
I'll tackle this one. So first, it really depends on what you are having them do, number one, right? Are you having them draft contracts for you and conduct due diligence on a real estate deal? Then absolutely a lawyer, right? Because they draft legal agreements. That's what lawyers do. That's absolutely up their wheelhouse. Are you having them do a compliance program for your company? That might also be a lawyer, especially if it's legal compliance, right? Because in cannabis, you got two competing things going on. You got business compliance, which is sometimes legal, but not always legal, because sometimes that's financial and accounting, right? And then you got legal compliance heavy on it. So when I talk to people about putting together a dream team for a CBE, I talk to them about having both. I talk about having lawyers to do legal things, because especially because of how expensive lawyers can be, you can keep them in that legal lane. And then I talk about having consultants do consultant things. One of the reasons why you want to be careful using a consultant for everything as opposed to a lawyer is, one, they're not a lawyer. And this is a highly regulated industry with lots of laws and regulations. And two, consultants' loyalties to their clients are very different. And this is a competitive landscape. So a consultant could be possibly using your intel while working with other clients in a way that lawyers, we ain't supposed to roll like that. All right, that's unethical. Okay, so really have to think about like, what are you using them for, and creating your business plan around your budget around what am I using them for. The other good thing a lawyer can do is look at your consultant agreement to protect you. We can look at that. We can do that due diligence. How are they charging you? What exactly is their scope of work? What is our deliverables under this? What are their assurances, if any? What are their representations? So those are the kind of things where when you bypass a lawyer, you end up in a worse situation because you were trying to either decrease your bill or for whatever reason you didn't know, but you still end up with a more expensive deal. Because here is one thing I know for certain about my people. It costs you way more to get out of it. Our prices, the way we look at litigation versus transaction, is we look at it as when you're traveling, check bags versus lost luggage. That's how we arrange our fee structure, all right? When you check bags, that's me, transactional, regulatory. I'm seeing down the line, hey, hold on, the weather is looking bad over where you're going. You might want to take your raincoat, your rain boots. That's what transactional regulatory attorneys do. All right. When I was in litigation, I was working in lost luggage. Oops. I didn't do it right on the front end. I didn't create a good operational agreement with my business partners. I didn't actually have a contract with this consultant. I didn't, and it's like that costs way more because now we go into court, we got court fees, and so it's just, it depends on what you're using them for.
I love that analogy.
It's my favorite.
Me too.
Okay, next question. If social equity requires that you live in a DIA and is all caps, so there's an emphasis there, and you or a family member has had legal cannabis issues, is this creating a legal special class similar to veterans?
I would be very careful about looking at that part of the bill text. One, because I would prefer if you told me where you were looking at that at. Tricia knows me. Like, if you could drop in here which part of the bill you're looking at that sees that, because sometimes people think they see an and when it's not. And so I just got to make sure. I would love to look at it. So I'm going to temper my response with I'm not looking at the legislation, because the way lawyers work is we actually look at the law before we answer questions. And so what I'll say is not looking at it, just a high level answer is I wouldn't compare these two things. I would not compare the social equity and veteran issue, because what's going on with the veteran issue, the main central point that's going on is it's required in terms of that perfect score component. And it doesn't necessarily mean that's the case with this.
You mean clarify, you mean the veteran is required for the perfect score?
For the perfect score, right. Mm-hmm. Whereas this doesn't necessarily mean that. You see what I'm saying, Tricia?
Mm-hmm, mm-hmm.
So that's why that particular category is under so much scrutiny, because at this point you have to be a veteran.
And that seems to be one of the controversies around that, is that it seems to be a deviation from how the legislation was originally written.
Right, which gets into legislative intent, which is what courts look at.
Yep.
Courts look at what was the legislator's intent, which they see in all those opening paragraphs and all throughout the bill. We want to repair harms from the war on drugs. We want to repair all that mass incarceration we did. Oops. We want to do, and so that, and then a court decides, is that reasonable and lawful intent?
I think that's an important point when you talk about legislative intent and was it met? And ultimately, in this particular case, veteran status ultimately superseded social equity, which I'm sure wasn't the intent. And so as we move forward, I think it's really important that we make sure that we meet that intent next time. And hopefully everybody that is intended to benefit from the program does. And we're more inclusion, if there's more inclusion opposed to exclusivity.
Right.
Or, of the wrong groups.
Right. Okay, the next question is, where would you recommend someone interested in growing industrial hemp turn for information on barriers to entry? I'm going to chime in and say one great resource is a Small Business Development Center. They actually already have programming around this because hemp is not federally illegal. And so they have great free resources around hemp, and they've been doing things around hemp for the last few years.
And the Department of Ag's website.
There too.
Tons of links, tons of information.
And we also at SEEN, we do have a number of hemp growers, including myself. So we are a resource for hemp growers as well. So please check us out.
Great question. You just got 3 great resources in that one question. All right, next question, Tricia. I guess that's me. You spoke about controlling the narrative by preparing your own press release. Could you summarize those recommended points to include in a press release? I'm going to say part of it is going to be dependent on what the press release is about. Because if you're like promoting events or things of that nature versus putting things out there. For example, if I'm promoting an event for my business, that's one type of press release. If I'm letting people know that I just got this great contract with DCEO or IC, that's somewhat different in terms of what I put in the press release. So the best thing that I could recommend is to Google press release, because you will find tons of sample press releases out there, and you can craft yours, similar to the ones that you see out there. But in general, what I would say as a rule of thumb is to always include a quote, because it makes it look like they talked to you and they didn't. So then when they write the story, they already have a quote. They don't have to call you, and the story can just run as is, just about. If it's crafted really well, and I'm a writer, so if it's crafted really well, they don't even have to call you. You'll just look up and be like, oh yeah, my stuff just ran. Make sure, so basically you want to put, you can craft your own headline. You know, local business wins license. Local business is going after a cannabis license. Local business attended a lobby day to do X, Y, and Z. There's so many different things. And then put all the most pertinent details at the beginning, because the framework of media is stuff can get cut even after it's written, and it's cut from the end and not the beginning. So you want to put all the most pertinent things at the beginning. Always include a quote, and always include your contact information. Those are just very high level details. But then and if you've never written a press release before, Google is a great resource. Even as a person who has a journalism degree, I have still sometimes gone and looked at other people's press releases just to see what other things that people might be putting in press releases that I might like, oh yeah, I like that, I'm gonna put that in mine. So next question is, concerned that emergency rules are for 180 days, during which an original and second lottery and medical cannabis lottery and a social justice lottery are being proposed. My concerns are medical and justice lotteries seem limited to ex-cannabis felons. Is this discriminatory to long-term DIA residents who never were jailed? And two, the craft says you can get multiple licenses based on capacity. Isn't that anti-social equity? Who wants to jump on that?
I think the first one is adequate for SAO to chime in on. It's more of an attorney.
Okay, I just want to make sure, because I know, there's a lot of perspectives on this stuff. There's that legal perspective, there's that policy perspective, and you all always do an excellent job, I think, of connecting the policy. So I didn't want to like go all legal on every question. So once again, just for practice sake, I always say, let's get to the citation. Which part of the law are you talking about here, right? Because whenever you ask me a question, and any lawyer that is, especially a regulatory lawyer, will say, always tell me where section, what page you're on, because it matters. These things matter a lot. And so I think I know where you are, but again, I'm going to say, there's going to be a high level answer because I don't have an immediate citation sitting in front of me to process. The first one about it being discriminatory towards long-term DI residences who were never jailed, I would caution you about the use of discriminatory in terms of that has legal meaning and legal implications. And it usually has to do with protected classes and things like that. So, and I say that to say that is way out of my wheelhouse in terms of what I practice as an attorney. My husband, on the other hand, who spent a lot of his regulatory career practicing administrative law specifically for discrimination, that's the kind of attorney that you want to turn to for a question like that. Because from my limited understanding of that area of law, I'm not inclined to say yes to your question. I'm not inclined to say discriminatory just because of how I interpret that and the significance of the legal meaning of that word. So the next thing I would say, as someone who grew up in a DIA and is very lucky to have evaded mass incarceration, is that I think that there are some benefits from a policy level to having some benefits for our brothers and sisters who were impacted by mass incarceration specifically, because in this war zone, we were not all impacted the same. And folks that were impacted through mass incarceration were not able to become highly sought after regulatory attorneys like myself. And they are dealing with completely different life circumstances, life challenges, and life hurdles compared to a person who grew up in a DA like myself who did not face mass incarceration. So just from two perspectives, from the legal perspective, I'm not inclined to go that direction for thought. And from a policy perspective, I'm not either.
Can I just add that I do see the concern because the original text, the current law, does allow for they took under consideration free lunch programs. They took under consideration the poverty level, the unemployment level, the over policing in certain areas, as well as the people that were directly harmed. I think that it's important that we look at social equity as from a global standpoint and from macro. And I think the concern there, if I do understand the question, is that it then exclusively only applies to people that were directly harmed versus those that were also indirectly harmed by just living in these residential areas. And as we all know, the public school systems, the tax brackets, everything is different in these areas that were disenfranchised. And so ultimately, I think that it is fair enough to say that all social equity applicants, including those both directly and indirectly harmed, should have the opportunity to participate. And so I think that's where the concern is. But ultimately, absolutely agree with what you're saying. Being directly harmed and directly incarcerated and a victim of mass incarceration should have some definite credence in that as well. And so, you know, there's certain areas such as Oakland and California that do tiered systems. Whereas certain amount of points are given to people that were directly harmed versus indirectly harmed. And that's something that it may be a good idea for us here in Illinois to consider.
Yeah, and that's exactly why I thought it was important for us all to be here tonight, because I do think that legislative advocacy necessarily requires multiple perspectives, you know, and so I appreciate your perspective. And I certainly always take the position of not pitting folks who have been harmed against each other, that those things are not in conflict with each other. And that it was mostly my overarching point was like, they're not in conflict with me. I don't look at them that way. And I look at them as separate harms, and I don't look at direct as being worse than indirect either. I don't. We all experienced our different form of warfare. And so I think when I'm looking at the bill, I'm looking at how much reparations is happening.
What about the second part of the question? Does anybody want to chime in on that? Multiple licenses based on capacity and whether or not that's anti-social equity.
Well, just to give my personal thoughts on it, I mean, the craft grow licenses right now in terms of the legislation only limits you to one license. And obviously they're limited by 40, and it's a very competitive license. I mean, there's 459 applications, and the opportunity for an individual entity to get multiple license obviously creates certain dynamics where you have a lot more monopolies and certain individuals or entities kind of controlling the supply. And I think that is concerning for social equity applicants, considering that we're still dealing with these MSOs, these multi-state operators, and the monopoly that they already have on the supply. So I think it should be looked at and scrutinized, because we do want to create diversity, more diverse ownership among our social equity community. So I think it's just something that really does need to take a look at, and we need to be careful how we move forward in that.
Okay. Next question. I am a veteran and partner, and my partner and I both are social equity. Can you repeat what the new law change is? Sorry, came on late. Thank you. There are a lot of changes. So
I think they should rewind it, because we're recording it. And so my suggestion is to rewind it and also take a look at the slideshow, which does a summary of it on one of the pages. It gives a nice kind of condensed summary.
And the slideshow
question. I'm sorry to cut you off, Tricia.
I was just going to ask, and the slideshow is in your box. Okay.
I was just gonna say it's there, the law has not changed yet. These are proposed changes. So I just wanted to let her know that the session hasn't ended and these are actual bills that are being proposed and have not been voted on or signed into law yet.
Okay, thank you so much for saying that. Next question is HB 327 definition of social equity. Oh, okay, so this is a follow-up to the previous question. It also asked for 2 of residency and either you had legal issues or family members. So it's not really more than 2 options, or 2 options involve arrest, conviction, etc.
It sounds like this is getting back to that critical point that's being debated in this whole legislative cycle right now, which is around how should this look? Should it look like something that's getting more specific about the mass incarceration and the mass arrest, or should it be broader than that? How narrow, how broad? But I'm not really sure, you know, in terms of like this being a Q&A, I think that these are things that we all have to individually consider and decide where we stand on it and where we want to lobby and what groups are supporting of our position so that we can get involved.
Right. So yeah, and so just to remind everyone, because I was like, well, let me go back and look at the questions that have been cleared already. So the original question was, if social equity requires that you live in a DIA and you or your family member had a legal cannabis issue, is this creating a legal special class similar to veterans? So, and so then what the law she's talking, or the proposed law that she's talking about is 327, which is a proposal to change the definition of social equity. So if you want to take a look at that, SL, while I go to the next question, I'll leave this open if you want to, or.
I'm not, only because I think that this is just a broad sort of like, do you agree or disagree? And you know what I mean? You know what I mean? Right. So it's like, I mean, are you asking me like, you know, as like me personally, or, you know, it's one of those things where I don't think there's a right or wrong answer. Right. I think that for me, my position in this workshop is what, like I did when I was going through the slides, what kind of like neutral questions are out there to help you get to whatever your bias or slant or lobby position is going to be. Right. And the neutral question here that I think exists is, how broad or how narrow should the social equity applicant definition be? How targeted, and targeted for what? I think one of the things I did say was that I believe in a very broad lens for what reparations are owed to war zones. So from my perspective, anything that can get us to make sure that everyone has an opportunity to have their rights wronged is a good policy indeed. Right. That's me. But then we're going to have different groups. There are going to be groups that are like, I'm heavy on the mass incarceration prohibition tip. That's my special interest, you know? And so those groups are going to be lobbying for a different position, perhaps. You know, so that's why during the presentation, I was very careful to get into slanted questioning or slanted sort, because I did want to sort of make sure that everyone understood at the end of the day, this is for you to decide what your stance is.
And so to piggyback what SL just said, if you take those tools that were provided for you to be able to then fill in that chart and then determine, now that I have all this information and it's staring me in the face, when I contact my state rep and when I contact my state senator, this is what I want to say to them about this, because this is what this proposed change means to me or means to businesses like mine. So next question is, there is a commingling and HB 327 of changes to multiple laws, including compassionate use and CRTA and craft licensing. Is this commingling allowable all in one bill?
Yes, because the proposal is talking about making changes to various laws throughout the state. And you'll see that in numerous bills, like that bill about events and consumption licenses makes changes to the Illinois Smoke-Free Act.
Mm-hmm.
Just to give you an example of this being commonplace. That's what makes this so confusing for folks that are not fluent in law. And that's why I'm really encouraging folks to organize in some of the ways that I advised and educated on in this course, because it might seem like, oh, do I really need to do this kind of tedious sort of filling out the chart? And yes, because that's how you're going to really get a clear, organized perspective of what's going on with each of these, because that's that cross-reference that I was talking about. Now we're cross-referencing the Administrative Rule Act. Whoa, how did that get in there? What I thought y'all what we were doing here. So that's, you know, that's where you want to do the cross-referencing. But yeah, that's allowable.
Next question, what is SEAM's stance on funding in the social equity policy?
Great question. Obviously, that is a very important element that actually in this bill got missed. And that is critical because, as we know, you can't think about social equity without thinking about funding and how critical it is, especially for us. I mean, that's one area in terms of capital. We always, we always have some issues with, and I think that's definitely something that got missed and needs to be addressed to assist social equity applicants with starting up their businesses, not just, trying to be in operation, and taking a look at other opportunities of funding that is potentially available that can assist us with reallocating funds to our schools, especially schools that service those in DIA areas, those that, programming. I mean, those things need to be taken a look at as it relates to funding. And so that, when you think about social equity, you also have to include sources of funding for that.
I completely agree. I always think about the illustration that is really infamous that's been going around, that illustrates equality and it illustrates equity, and it shows like a baby, a kid, and a older person maybe, or people of three different age groups. You can put them on even playing field and they still don't get to see the game. Or you can give them exactly the amount of books that they need in this illustration in order for them to reach the height that they need to see over the fence. And so I think that illustrates exactly what equity is versus equality, and how this movement is completely different from the one that we passed in the 60s that, or I wasn't even around. So I know that was a completely different movement. The difference in this, though, is that we recognize that because of all the years of harm and all the years of injustice and all the years of uneven playing fields, that we need to provide certain resources to certain people that have not been able to be afforded these opportunities. And so I think that I do want to acknowledge the state for doing a loan program. There are several states that have missed the mark completely. But I will say that it would behoove us to look at startup, because ultimately the loans are only available once you're operational. And we all know that it's hard enough to just get started, let alone operational. And so majority of your costs and your capital is needed on the front end, opposed to once you're up and running. And so it's important that we take a lot of the funds and reallocate them to advocate for, as well as education. Educating, I know there is a bill out there that is allocating some money towards some type of policing education, and that's important as well. But I think that if we have the opportunity, because community engagement is involved in this process, if we really give these businesses the funding and the opportunities that they need to succeed, then we have the capability of truly engaging the community by way of education, by way of just changing the culture in general. And so I read also a person say that policy change is one thing, but culture eats policy for lunch. And so unless we actually change the culture and the way we're thinking about equity and what it means, we can write policy all day long and change laws, but we need to actually implement the finances and the funding and all of the resources that are needed in order for this policy to really be impactful and successful.
I'd like to add something, even though this is a Scene question, but because I think it really supports and affirms what Scene is saying. Law resources. I think that over the last 2 years, I've seen that really makes a difference for applicants in terms of that startup cost. Not a lot of folks can afford to put an attorney retainer together. And the first iteration of the laws kind of suggested, hinted at that it was going to help with that. And as of right now, I mean, what's actually happening? You know, I'm doing the best that I can, but it's like I'm a one-woman show here at the end of the day in terms of the accessible legal sources. I'm not saying it's not stuff on the private market, but I mean stuff that folks don't necessarily have to have a retainer to get access to this legal perspective. So I definitely would love to see more specific. In the legal industry, there is a movement called Civil Gideon, which has to do with creating a right to civil lawyers and not just criminal lawyers, which is how the American system works. So basically you have to be dealing with like some like extreme hardship to get access to a lawyer in terms of the resources. And there's a movement of lawyers that's saying, hey, how about we also help people get out of poverty by giving them access to business lawyers and family lawyers and, you know, all of these other kind of things that can help people improve their circumstances. On a professional level, I am a huge fan of enacting Civil Gideon measures within cannabis legislation because I think that it will help level the playing field.
And I will add to that for those of you who do not know, because she didn't say this, but I will, that SL also has advocated directly to the state for there to be more legal resources available for free to you under the same contract that we are under now, because we know that one of the biggest gaps that we've seen, particularly for people who are trying to write their own application, and this is complex legal work, that it is a steep uphill climb to compete with people who have big pockets and have, you know, an army of attorneys available to them. So how can you compete as a social equity who grew up or still lives in a DIA and then expect to come in and compete with a group that has put in, as in the dispensary round, 13 applications? So the only way for you to be able to compete and ensure that your application is on par with some of these big money groups is for you to be able to have a legal resource available to you, even if it's not to write your application, at least to possibly assist you with that process in some way, to answer questions, to review things, you know. Just like SL, I've done the best that I can, you know, reviewing people's applications and looking for gaps, comparing their application to the letter of the law, you know, and the letter of the instructions to see if there's anything that might possibly be missing. But there's only so much that can be done when there's hundreds of people.
Mm-hmm. Civil measures are missing. That's a missing piece to saying, oh, we're going to create this social equity applicant program. And you're going to be competing against MSOs and big money investors. And good luck, you got it. Oh, and you're going to have a very complex administrative process that has to do with deficiency notices and that has real legal implications and outcomes for you. But you know, you got this. Like, so to me, it sort of is like a necessary component to truly empower social equity applicants to access this industry.
Yes, and when I say SL advocated, I want to make sure that you all are aware of who that advocacy was with, That was with the governor's office directly. That was with Department of Agriculture directly. That was with people who are actually making the decisions about our contracts, because our contracts weren't necessarily written into the law. Somebody made a decision somewhere that said, hey, we need to do this. So we're saying in the future, when you do this, based on us being in this space and having been in this space for the last year, here's how you can do it better. So I want you to know that SL has been a big advocate for all of you and for the process becoming better as things move forward.
I thank you. I thank you for that, because that's important to shed light on it, because of exactly what we're talking about. The lack of resources, we need voices. And so that's what you said is the exact reason why SANE was born, because we recognize that because of the lack of resources, it's going to be important for all the social equity applicants to band together, tap into resources such as this, and also just sharing with one another, sharing resources, sharing education, sharing information, providing ourselves with buying power as a collective, and just being an impenetrable force so that we together can have a little more power more than we would standing alone, because we are up against multi-state operators, billionaires, millionaires, people that are able to put in not just 30, but hundreds of applications in several states, not just in Illinois. Right. And so this is the game. This is what they do. They eat, breathe, and live this. And so we have become advocates outside of being parents, outside of having full-time jobs. And we are literally rolled up our sleeves. We've registered to lobby. We have 3 registered lobbyists here that are on the ground as advocates that are taking this very seriously, because it's really bigger than cannabis. This is an entrepreneurial opportunity that can create generational wealth. And it also is the economic empowerment that our communities need to stop turning on the news and hearing about the carjackings and all of the bad stories that you hear that we don't, we want to be able to uplift these communities and our communities that we come from, everywhere from Austin, to the south side of Chicago and beyond, to East St. Louis and all the other areas that suffer in the state. So it's really important that we really pay attention to how important this opportunity is. And so that's kind of exactly why we're here.
And I think the other thing that's important is that the people who get involved, particularly as it relates to the state contract side and providing that support, are not people who have skin in the game. I'm not going after a cannabis contract. SL is not going after a cannabis contract. We're here to help. There is no opportunity for us to have. There's no issues with disclosure and who we're loyal to and any of that. We just want everybody to win and be able to compete.
Yeah, because it's difficult, I think, and we saw that over the last year when you have folks that are supposed to provide technical assistance that are all for the same exact applications that they're competing for at the same exact time. I think there has to be some parameters around that. I think one of the things that has made people feel safe with me over this last year is that I'm not applying for a cannabis business license and competing with them. So, I mean, just imagine what kind of imbalance of power that would be. Am I really going to be giving you my best secret sauce if I'm in the competition at this very moment? It's like, that's not, and so that's why Tricia's saying that, because we've been very vocal about, hey, we're a good resource because we have absolutely no CBE skin in the game.
Yeah, we have no conflicts of interest.
No.
And that's important.
In my household, our business is lawyering and educating. We are law professors and we are attorneys. So that's our cannabis play. Okay, so I'm not saying we don't have a cannabis play. All right, I'm saying our cannabis play is in the legal industry around educating and being attorneys, and actually primarily educating. Like, we're primarily law professors. That's what we primarily are. Just because it could be kind of sticky representing multiple CBEs. Yeah.
Yep.
So we actually don't do that. We don't represent any, and we instead educate, because we can make that accessible to everybody. And that's, you know, that levels the playing field, and that's our advocacy. That's how we do it.
And it's the same here.
Yeah.
You know, my business is entrepreneurship and education. And cannabis business to me is like any other business. There's obviously a whole lot more regulatory requirements in this business, but I'm just about seeing the unlikely entrepreneurs, or the people who need to have equity get that boost that they need so that they can succeed and compete with the big dogs. And so that's what I do in my business in general, with any type of business.
I think that's why I appreciate what you led with due diligence. I think that's so important, which the topic that you're talking about now, because conflicts do exist and people do misrepresent themselves. And so it's important that we educate ourselves on who we engage with as we navigate these business opportunities, because conflicted individuals can impede on your opportunities, and that's the last thing you want when you're spending your heart and soul, you know, beyond money and time. We're spending our heart and soul on this process because we believe that we do deserve this opportunity. And so I really want to thank you for leading that, because doing your due diligence and your research on anybody that you engage is ultimately so important.
And I already updated that due diligence list for y'all to add 3 more resources.
And I think one of the things that needs to be asked is, are you going after a license? Just point blank ask the question.
I agree.
Are you? Because
it's a fair question if someone is saying they're conducting a service or business with you. That's like a fair question. That's not you know, if you're just talking to someone who's not providing a service to you, they're gonna be like, hold on, you in my business, don't do that, right? But that's just a private citizen not provide, you know. So, but if you're talking about someone who says, hey, pay me for workshops, or come to a free workshop paid for by somebody else, or pay me for my advice and consulting, I think it's a fair question as part of your due diligence to say, are you currently competing for a license? And even further than that, how else are you involved in the licensing competition? Are you supporting other licensees? If they're a lawyer, that's still a good question, because we got regulatory rules, but I can tell you in certain highly competitive markets, I've been involved in, especially in my time working in big law firms, where certain clients will let you know as part of their engagement, I'm your only and best, because they want to keep that lawyer all to themselves. Now, that costs money, but it happens where they say, I don't want you representing my #1 competitor in tech. You only represent me. You're not doing me and all the other tech companies. You're not doing me and all the other manufacturers who do this, and that. You know, they ask their lawyers for those type of agreements, and with the right deal, it happens, because that's how competitive some industries are. And this is one of them. You got to know who's competing when you're dealing with them.
And let me also disclose this, that one of the things the state did do when we entered into this contract is that we did have to disclose, are we involved in any application period? Whether it's we assisted, any of that, there was a disclosure process. So the state has done its due diligence for those of us who went through that competitive process to apply to get this contract, that we had to disclose all of that up front before we inked the contract. So I want to make sure that you're aware of that as well. All right. Let me get to
I answered this one in the chat.
Oh, you did? Okay. So the schedule is in the chat. Next question is, so is it correct, and what was stated, that it is perfectly legal to transfer medical licenses from the Compassionate Use of Medical Cannabis Pilot Program Act of 2014 to the adult use licenses without allowing for medical licensees to have the option to apply for those existing licenses?
I don't know why that's being interpreted that way, other than the fact that they are in the same proposal document. And so what I'm going to say is, I don't think that that's That's I don't think that's what's happening. In this, I think what's happening is there's some confusion because you're seeing so many you're seeing changes to the Compassion Use Medical Cannabis Pilot Program Act. You're seeing changes to that proposed in this same bill that is proposing changes to the CRTA, the Cannabis Regulation and Tax Act, as well as to the Illinois Administrative Law Rule, right? And so the section that you're talking about is not changing the medical licensing program by way of the adult use program. Those are two separate things. That's the first part. And then the second part, the part that you're talking about is talking about creating a social equity program in the medical dispensary licensing program under the Cannabis Compassionate Use of Medical Cannabis Pilot Program Act. All right. So the question I think you might want to ask is, do you agree with creating these social equity dispensary provisions to open up access to social equity applicants to own a medical dispensary license? I don't want to put words in your mouth though. I'm just telling you that's what I think you might be really wanting to ask, because the question you're asking is not a thing. It's not happening. They're changing the law of the medical licensing program. And from that perspective, you're asking yourself, do you like that? Mm-hmm. Now, the other thing that I'm asking when I'm looking at this is, what's the supply chain feel right now? Who owns medical dispensary licenses for the last 6-7 years? Who do they look like and where are they from? Were they harmed by the war on drugs? Are they diverse? Are they big money, small business owners? Do they reflect the diversity of the state of Illinois? Those are questions I'm asking when I'm looking to see what do I personally agree with in something around my own policy objectives. And then to the last part of what you're saying is, without allowing medical licensees to have the option to apply for these existing licenses, I think is also misplaced and out of context, because when adult use was legalized, the CRTA allowed for medical dispensaries to have the first grab at adult use licenses. And nobody flinched until and by nobody, I mean the legislature didn't flinch. It seems to pass with easy peasy. And, you know, and then people realize, like, hold on, wait a minute, what is this going to do to competition? What is it going to do to new market entrants? That pretty much created a non-competitive process. Remember, you guys were asking me about the difference between competitive and non-competitive. That was a non-competitive process. So I think I'll leave it right there.
You spoke a word. That was a word in itself. I mean, when you're talking about the previous round, no one flinched at the fact that there was no Black ownership for the last 7 years. No one flinched at the fact that you're now creating a new a new industry that was historically locking people up. In fact, people are still imprisoned. And now you have a whole new demographic, a different demographic of people that have now legalized and monopolized it. And so I think that it's important that every state look at legalization of marijuana, we need to look at the whole scope and how they are monopolizing it and taking a sector of the market and calling it medicinal and not even thinking about social equity at the onset of a lot of these legislations as they roll into. And so I think that we need to start flinching. I do. I think that we need to start paying attention to these legislations as they are ensued and how they impact the people that should be.
Mm-hmm. Next question. The Illinois State Legislature is currently in session. Is there still time for people not in Springfield to express individual concerns regarding the proposed changes? Yes, that is the whole reason why we're here tonight. You want to do that now before those come up for vote.
And seen as definitely advocating continuously. You can chime in to us on an ongoing basis. We are definitely here to educate everyone on what this means, and that's why we participate and welcome these opportunities for sure.
And I would say what you want to do is call your representative and your senators, your representative, maybe more than one, your representatives and your senator, and tell them your stance on this, and make sure you get an audience with them. They are, well, at least locally, I feel like they're easy to reach. I can't speak for everybody. So for me, they're easy to reach. But you definitely want to do that before they come up for a vote. We can have all the resources, but if we are unable to obtain entry into the cannabis industry through obtaining licenses, what is the benefit?
I would say that's a personal decision that's based on whether you want to compete and what you think the risk benefit analysis is of engaging in a competition that's highly competitive, and a possibility of winner takes all and loser loses all.
Okay, next question. Seen as a trade organization that is chartered to work on behalf of their members, they are licensed applicants who understand the needs of other applicants, since they are all in the trenches and clinging together to keep hope alive. So I think that's just a thumbs up for Seen.
Oh, thank you very much, guys. It's about really empowering our people with knowledge and information and, education. And we know that we're going to do it. And we're not just about cannabis, but also the ancillary businesses, guys. This is an ecosystem. So if you have a transportation company, and this one has a craft grow, this one has a dispensary, and this one is an electrician, and this one is an HVAC technician and a plumber over here, those vehicles are going to need to have tires. And we know that what we want to do is reach out to our communities, because we know we have entrepreneurs who are in various spaces. And this is an opportunity to build that ecosystem to help transform our community. So I definitely appreciate it, but I don't want people, we're not just about cannabis, but this is also about these ancillary businesses. And whether you're in social consumption or a plumber, you have a place in Seen.
And I think it's important to note that those ancillary businesses are important because, one, of the regulatory nature of this industry, and then also because from the perspective of those other businesses, it can be specialized depending on what the business is. And there can also be obstacles and hurdles that come along for those businesses because they're dealing with cannabis businesses, particularly as it relates to banking, which is one of the things that came up in one of our earlier webinars on banking, that as soon as a bank finds out that, oh, you doing business with cannabis businesses, and now we can't have your money in our bank, right? So I'm glad that you brought that up, Natasha, because those ancillary businesses are vitally important for those of you who decide that I want to be in the cannabis industry and be in this business, to be able to know that who you're dealing with understands the business that you're in and the requirements of the business that you're in. Okay, so next is, okay, thank you for your comments about attorneys and disclosures about conflicts of interest. You're very welcome. We're here to serve you all. So it doesn't, this is probably a follow-up to, okay, yes, these two questions go together. So it doesn't have to be amended, it's already created, and I think the second one goes with it, 410 Illinois Compiled Statute 705/7-1A. My interpretation of this is that you're talking about a proposal, and that there's nothing that's out there right now, all we're talking about is proposals. None of this stuff has been passed yet. And I'm not sure if that's what you're asking, or if it's something else. Does anybody else have a different interpretation of this? No? Okay. So Debbie, if we didn't address what it is that you're trying to say, type another question. In a recent article, it was reported that a company is opening a consumption space in Wrigley. Are you aware of how they were able to bypass the city regulations against indoor smoking?
I don't think it was in Wrigley. I think it was in another small town, but I know how that happened because I got a little charge too. The way the publication did the byline, it was next to something related to Wrigley. And I think a bunch of us initially thought like, what, Wrigley Field, Northside getting but if you opened it up, it told you like it was in some other small town in Illinois. So I just want to clarify that first. And then second, I think that what ended up happening is that that local municipality decided to allow it and to see whether the state was going to challenge it. And the state is not challenging it. And in fact, in the middle of proposing changing the law.
We know from what's happened with the mask mandates that local municipalities just do what they want to do, and we wait and see what happens. We just go let the chips fall where they may. So, okay. So Debbie said there were findings in the CRTA that the General Assembly addressed. But I think we've already answered. Yeah.
I think you clarified already his proposals.
Yep. And I think that that is it in terms of live questions. So before I close out, because I always, okay, so Debbie says, thank you, you're welcome. And she says, appreciate you again, you're welcome. This is why we do what we do. So before I close out, I want to give anybody and everybody opportunity to type their final questions. I will finish typing the answer to the one open question, and I'll open for you guys to make any closing comments you might have.
Well, I want to thank you all for this opportunity and also encourage everyone that's out there watching this. Please check us out. Our scenes website is www.equityempower.org. You can also reach us at hello@equityempower.org. That's our email address. We are definitely on Facebook at Equity Empowerment, Social Equity Empowerment, and we are on Twitter and LinkedIn as well. But I just want to thank you for this opportunity. We definitely want people to reach out to us. We are a resource for you. And this is something that we'll do together. And coming into these types of spaces and having this type of dialogue is very critical for our success in helping to drive that needle towards social equity. I'll pass it on to.
Okay, so before anybody else chimes in, of course, we got two more things in the Q&A box. Tricia, you have been doing a great job. Well, thank you. I've been following you for months now, and you have great guests. Will you have one with all the activists or groups on that are trying to help ensure social equality is done right? I would like to get more involved. So I'll answer that. We actually did one previously. Yeah, we did one in the summer. It's been so long.
September-ish.
Yeah, okay, maybe you're right. It's probably around September.
Mm-hmm.
Yep. So we did one with the ICCA, which is Illinois Craft Cannabis Association, and we did, and SEEM, both were on at the same time. If there are other groups that I'm not aware of that you feel like I need to be made aware of, let me know. I am aware of both. I've been aware of both ICCA and SEEM for quite some time. So when that one came about, it was because I reached out to them and said, hey, I know you guys are all doing work in different ways, in different lanes, and I felt like people needed to know what was available. So we did do that one. Those recordings, all of our previous webinars are actually on our website now. So you can go to cannabistrainingil.com, go to webinars, and you will see a list of all of our recordings right there. And you can watch them, so you can watch that one. There might be webinars in our future. I'll be honest, I feel like I have exhausted everything I could possibly think of to do while we've been waiting on these licenses that haven't come yet.
Until I call her.
But if you have a topic or something that you feel like needs to be covered that we haven't done, please let me know, because the reason why we've done these webinars, This was not part of our original program. When I wrote my original proposal to the state, none of these the only webinars that were included were the ones pre-licensed. The reason why we've done this is because, one, the licenses aren't out yet, and we've been waiting on the state all this time. Two, I'm an entrepreneur. So I was already asking the question, what else do you need? What else do you want from me? Because I'm thinking ahead. And then when the state came back to me and said, hey, what else can you do? And I was like, oh, well, I already have a list. So I can do future webinars if I feel like it's going to be something that will serve everybody. And it's going to be a topic that I know you will need, not just now, but in the future as you create and grow your businesses. And so I'm open to any feedback that you have on that. So feel free to send me an email. Next question, last question. Do you feel that there will ever be parity in the Illinois cannabis industry? That's a loaded question.
I'm guessing everybody has a perspective on this. My perspective on this is that it will continue to be an uphill battle. Whenever you're dealing with a loaded word like war zone, disproportionately impacted areas, we're talking about injustices that happened over generations, and they're not going to be undone in one bill cycle or two bill cycles. And whenever you're talking about an emerging regulated industry, the fixes are going to be continuous, which is why it's important to be politically active and politically involved and find your interest groups that are aligned with your value system so that you can have cohesion and real exacting measures in the market. So the answer is maybe. When? I don't know. I think the law is going to keep changing for the next several years.
I'm gonna wait. I'm not gonna say anything. I'm gonna wait. I'm gonna wait till you all chime in before I say anything. I have the least amount of skin in this game than anybody. So
I just was gonna say I agree. It's an uphill battle. I mean, there was a quote that the governor said that really kind of, like SL said, got under my skin a while ago when they first came out with this with the license, the awardees. He said that it's a sprint, not a marathon. Mm-hmm. And so when you think about that, it's definitely, we need to sprint to a more viable solution, but this is an uphill battle and it will be a long road. It will be a long road to get parity. And so in doing so, I think that this by far is so important, because out of all of the stuff that we talked about, the education, the banking, the this, the that, and the other, all the topics of the seminars, here we are now talking about advocacy and how important it is to really pay attention to what's going on around you. Had we known more at the front end than we do now, and if we would have made different decisions, we would have been more involved then. And so I just can't stress it enough how important it is to have all hands on deck, paying attention to what's going on around us, being advocates, doing our due diligence, making sure, like you said, that you get involved with organizations that your interests align, where people are not conflicted, because all of this matters. Doing your research to making sure that you are equipped to enter into this industry. It's highly regulated. Yes, it's capital intensive, but it's really regulated, and it's heavy policy work. It really is, and that's the bulk of it.
Mm-hmm. I just wanted to piggyback off of that and just say I've just learned throughout this process how important it is for us as a people to become more aware of the policies that impact the economics of our communities. And whether it's from cannabis to gaming and all the other legislation that's out there, it's very critical for us to be aware of what's coming down the pike, because other people are paying attention. Other people are paying attention, and we need to do the same.
And I want to add to that I think that one of the critical components is kind of pulling at a magic 8 ball, which obviously doesn't really exist, but to be able to look to the future and possibly see the unintended consequences of specific changes. And I say that because where we are right now is a situation that has never existed before. Illinois did something new and different with its approach to social equity. And I'm sure that when they wrote it, they thought that they did the best that they could possibly do. But now we are dealing with a whole lot of unintended consequences in terms of the implementation of what they thought was the best that they could possibly do. So now we're in a situation where they're coming in on the back end trying to clean up what wasn't clearly ironed out and specified when they wrote it originally. And so because of that, we can look at this and go, okay, you know what? We might not have paid attention when they wrote it the first time because we were excited that it was finally happening and didn't see what the unintended consequences would be. But having gone through this already, let's look ahead and see if we can identify what some of those unintended consequences might be. And when we lobby our legislators, that we ask them to suggest changes or whatever is necessary so that we can mitigate those things and keep them from happening again in the future. Okay, so Natasha, you answered. Let's see, the remedy never matches the economic impact. Of course not. It's always going to be chicken and egg. Not sure that no bid contracts is the best we can do. So no bid contracts is not written into the law. That was somebody made an implementation decision that had nothing whatsoever to do with the law. What I'm talking about is social equity, those things that are written to the law. You have things that are written into the law, like the veteran stuff and the social equity thing, and then the implementation of that was based on somebody's interpretation of the law. But the law didn't say X or Y in terms of implementation. And so somebody said, okay, well, this is open to interpretation, so now we're doing this. And now it's gone to court for the judges to decide what the intent of the law was.
Tricia, can I give two thoughts that I have that I want to make sure we give before? One related to this. This person might also be getting at the proposed changes to the law that has to do with creating what probably could be called no bid, non-competitive licensing processes. And I understand, because there's always a give and take when you start moving away from the competitive system. And so I definitely think folks should really kind of look at those provisions, get with their cohorts, and really try to understand what that is about. And then the other thing I want to say about resources, because that was like a big word tonight. The DCEO was bills and legislation. The legislator empowers agencies, which some of you know from me from other workshops. And the reason I'm bringing that up and how it relates to resources is it even gets down to how Tricia and I are here tonight. The CRTA does have a provision in it that gets at the Department of Commerce and its ability to be able to provide resources to social equity applicants. And that is what empowered the Department of Commerce to solicit bids for technical assistance providers to compete for this opportunity. Just to kind of just make sure I fool around. And I'm bringing it up to say, like, so if you want to see resources that are required and mandated, you want to see lawyers, you want to see required legal counsel when you are doing the administrative process around deficiency notices, because that's a big one, that not having a lawyer, man, then those are things to consider advocating for as part of the bill, because that's how you get those things appropriated. So.
And I want to add to that And if you want to see changes in that process, and I say that specifically because when I first got involved, it was, I could tell you exact date. It was February 14th was the day that I got the phone call that I got the contract. The applications were due to the Department of Agriculture on March 15th. So we had we had a month exactly, 31 days, 4 weeks to implement and execute a program. And the dispensary applications were already in. And I believe the only resource that they had available was CSEC. So yes, it's in the law, but like SL said, they empowered them. That doesn't necessarily mean that it was as effective as you would like for it to be. So with that being said, there is also an opportunity for you to go to your legislators and have your legislators hold the agencies accountable for what you would like to see happen and changes as it relates to the support that we're able to provide. For example, when that support is available, because I know for a fact, because I first came on the scene in Chicago, let me think, it wasn't the 14th, it was the 28th, 2 weeks later, that people were like, we've been waiting on you, where you been?
And we've been advocating this though, Tricia. We've been also, this is part of the behind the scenes part of the advocacy we've been
absolutely
doing to the state to say, hey, to make these things more effective, we need more time. We need more heads up. I mean, we were putting together deficiency notice, technical assistance with 3 days notice. Like I was basically like, whoa, this is happening. Like I'm not getting a special alert, just so y'all know. I'm finding out from the trenches, and then I'm saying, let me go ahead and put this together in 48 hours. And so those are the type of things that we're advocating for, but it can be amended through legislation in terms of requiring agencies to follow a certain protocol around providing the resources, providing more resources. And, you know, I just came to the Social Equity Cannabis Initiative. This semester is really my first full semester. I came at the end of last semester. So it took them some time to find a cannabis specific attorney. So they had gotten involved with the agency, let's say a year ago, but it took some time because these are particular specialties. And so just keep in mind, like we need more head starts. That's why I love that idea. Like, do we really want to agree to a sprint? Because we need time to tool up. And it's hard to tool up in a sprint. In a marathon, you have time to build, you have time to collaborate, you have time to do more. And while we want it to happen fast, at the same time, fast and wrong is not good for anybody.
Right. And so, yeah, and my whole point in bringing all that up is to say, when you contact your legislators about the law changes, if you feel like there's more that could be done in terms of support, talk to them about what this process has been like for the last year so that they can hold the agencies accountable and possibly even write it into the law. Okay. Okay. So thank you, excellent panel. Not sure that no bid contracts is the best we can do. I think we just covered that. Not sure that the slave clause allowing businesses to be social equity by hiring is the best we could do. Thank you for that opinion. I'm going to say that I'm funded by DCEO and I'm not going to comment. The Cannabis Business Development Fund as a question.
I think that relates to where the funding sources are coming from for technical assistance, and the answer is yes.
Yep. And then frustrating to see that we have so many Black legislators, yet Blacks are moving backwards. Tell them, hold them, y'all voted for them, hold them accountable.
Hold them accountable, guys.
And
Let
I
me
think
tell you something.
That's where I'm coming from with the sprint and marathon, because we needed to do that fix on the front end. There's a lot of things that we see here that legislators didn't catch, you know, and now here we are causing more harm to those same people that were harmed, you know, and now we got to take our time and try to get it right when we could have done that before we made this legal.
Yeah, and I also feel like I'm gonna play devil's advocate and say hindsight is 2020. Because I feel like, oh, they thought they would pat, because we know they were patting themselves on the back saying, yes, we put together this social equity thing. This is great. This, that, and the other. And they've still been saying this is great. And it's up for you all to be, it's up to you all to tell them what you thought was great hurt me in this way. And if you don't tell them, they won't know. So, and I'm not saying you as in Belisha and Natasha, because I know you all have been telling them. I'm telling all the rest of you who are on here so that Belisha's voice and Natasha's voice are not the only voices, because the volume of voices makes a difference.
Absolutely.
Okay, so on that note, I believe that we are done. My mother is very hungry. My family has been texting back and forth while we've been here this whole time. I need to go feed my mama. So, well, my sister is at the water park. My mama's out there texting. Tricia's still on her Zoom. So, you all, thank you for coming. Thank you for joining us tonight. Thank you all who are here and who stay with us through the end. I hope this has been invaluable for all of you. I actually have notes that I took myself. Thank you very much, SL, for educating us as you always do.
Absolutely.
Thank you.
And for those of you who are attending, I will be sending out a survey in the next 48 hours. And have a great night, everyone.
Thank you all.
Good night.
Good
Thank
night.
you.
Thank you.
Yeah. Thank you, Belisha and Natasha, for all your great work.
Thank you.
Thank you so much. And yours too. Thank you both.
Good night.
Appreciate you
Good
guys.
night.
Bye-bye.